There was a lot of discussion about these examples of concerns with rubber stamping, right? And so, for instance, there had been a media report about an insurance company that allegedly used an algorithm to reject health insurance claims, with doctors who denied those claims spending an average of 1.2 seconds reviewing each request. And I think that was a prime example of what we didn't want to see happening.
Hello, and thank you for joining us on the AI Governance Podcast. I'm Matt McCallum, and today I'm joined by Phil Laird, General Counsel for the California Privacy Protection Agency. The CPPA is the primary enforcer of the California Consumer Privacy Act and the California Privacy Rights Act, and over the last couple of years it's become arguably the most consequential US-side voice on automated decision-making and AI governance through the ADMT regulations, the risk assessment requirements, and the work towards a centralised consumer rights platform that's now well underway. Phil leads the agency's legal function through all of that. He has spent his career at the intersection of technology, privacy, and regulation, and he's joining us today to talk through three things in particular: what California means by meaningful human involvement in automated decisions and how the agency is thinking about automation bias, the 2026-27 implementation roadmap on risk assessments and the drop platform, and what the agency means by frictionless and why that framing has come to matter so much. Phil, thank you so much for joining us.
Matt, thank you so much for having me. I'm delighted to be here.
No, it's great to have you on. So if I can start with the broader picture, Phil, and then we'll move into the specifics. You've been at the CPPA through the development of California's ADMT regulations. And before we get into the specific provisions, could you set the scene for our listeners? What's the CPPA's overall posture on automated decision-making technology, and how has that posture sharpened over the last 12 months?
Yeah, great question. First off, you're correct, Phil Laird. I'm the general counsel here at the agency, and I've been in this role for almost 4 years. So yes, have been with this development of these regulations for a while. The agency, just for quick background for your listeners, was established in 2020 by a voter initiative in California. So a proposition sort of established our agency, and the first staff arrived in 2021. So in terms of data protection authorities, we're pretty new to the scene, but we've been doing a lot of work in the last 5 years. We also continue to be the only government agency in the United States dedicated solely to consumer privacy regulation and enforcement. Now, in terms of your questions about ADMT, and if it's okay, automated decision-making technology, I'll say it once, and now I'm going to use the acronym for the rest of this
That's
conversation.
perfect.
In that proposition, we were given a laundry list of items to do rulemaking for. And one of those was a directive in the initiative to do regulations on ADMT, specifically governing opt-out and access rights with respect to ADMT.
Okay.
And when we began formal rulemaking, we started with initial rulemaking, with initial call for comments on this way back in 2021, and through various iterations of preliminary rulemaking until the final rulemaking process in 2024 and 2025, we finally landed the plane and adopted these final regulations just last year. And through that process, very robust stakeholder engagement, literally thousands of pages of public comment received on these topics. All that went into informing staff and our board that oversees our agencies sort of final decisions around what these regulations would entail.
Mm-hmm. Okay. Excellent. So, I mean, that sets up a perfect frame for my next question, getting a little more into the specifics. So, I mean, we say most regulatory frameworks gesture at human oversight or at human review. The ADMT regulations are, I think, unusually specific about what counts as meaningful human involvement. And for our audience of governance and privacy practitioners, what does that definition actually require, and what does it explicitly rule out?
Yeah, that's a really great question. And again, I'm going to take one baby step backwards and just also give you the context. So when I described that rulemaking mandate, that's essentially all we were given in the law. And so importantly, I'll flag automated decision-making technology itself, that term, that phrase, was not defined. And so this is a great example of why rulemaking definitions can be so important, because we really had to determine the scope of what we were talking about when we were talking about these new rights for Californians. And so in doing so, we considered a lot of things, including sort of risk to consumers, what we thought is appropriately understood in this day and age as automated decision-making technology and what goes into making a decision. And as I think you're touching upon, a big component of that is how much of the decision-making process is happening at the technology level or at the human level. And obviously that's can be a murky crossover area. And so our regulations essentially define automated decision-making technology as any process technology that processes personal information using computation
Hmm.
that replaces or substantially replaces human decision-making technology or decision-making, sorry. And then they clarify that we did go forward to clarify what replacing or substantially replacing human decision-making means
Yeah.
when using a technology's output to make a decision with human involvement. And so specifically, and again, part of this is born actually out of California's rulemaking requirements. There's this standard, and there's even a reviewing body that makes sure all regulations passed by the state meet certain clarity standards. And often that body that oversees that process won't allow you to get away with something to just say, like, substantially replace human decision making and not explain what human decision making what is. So we sort of by compulsion of California procedural laws, we needed to flesh this out more. So specifically, to answer your question, finally, it requires that the human reviewer know how to use and interpret the technology's output, review it and other relevant information, and have the authority to make or change the decision made by the ADMT. So you don't have human involvement if a reviewer doesn't understand what they're looking like. And similarly, if a human is not actually spending time reviewing the technology's output or doesn't have the authority to make or change the decision, that's not human involvement in a way that we thought meaningfully scoped you out of this concept of ADMT. And again, it can get a little funny as you think about these definitions because you've got sort of a definition within a definition within a definition. So to be clear, what we're talking about is whether or not our ADMT requirements actually apply to your use of a technology. Obviously, if you're using it as a tool and it's just one part of many tools that a human is actually using to make the decision themselves,
Yeah.
then the concept is you were scoped out of these requirements and you don't necessarily have to comply with those requirements. But if your human involvement sort of fails to meet one of those standards, then we are saying you are scoped into these requirements. You are now having to provide consumers access and opt-out rights with respect to your use of ADMT in sort of your business model.
Yeah. Okay. No, that's brilliant. That really that well, that does exactly what I asked. It clears it up because it gives us the when and the when not, which I think is the line everyone's trying to draw in their understanding. And yeah, it's interesting to get that journey of you having to work through that clarification yourselves, even to get that definition to be able to provide the ruling. So
And
excellent. Well, thank you.
if I can, I was just going to say, yes, to that point, if I can expand a little more, our board was really thoughtful about this, as well as the staff working on these regulations. And there was a lot of discussion about these examples of concerns with rubber stamping, right? And so, for instance, there had been a media report about an insurance company that allegedly used an algorithm to reject health insurance claims, with doctors who denied those claims spending an average of 1.2 seconds reviewing each request. And I think that was a prime example of what we didn't want to see happening.
Yes.
Or again, to be clear though, this isn't to say you can't do that. This is just to say if you were doing that, these ADMT requirements now apply to your use of ADMT.
Yes, absolutely. If that's the process, then yeah, you will be governed. That makes
Exactly.
sense. That makes perfect sense. So that actually takes me on to something else I wanted to look at with you, and it reminds me of it in a way, which is the idea of automation bias. And that's I'm not saying that that's what's happening in a 1.2 second medical decision, but it's that tendency of human reviewers to defer to an AI output. Um, the it becomes a problem or it becomes a bias whenever that output is wrong, obviously. And it was a major theme in a recent conversation we had on the podcast with former MEP Sophie de Velde. She pointed to a Dutch childcare benefit scandal where it was a stark example of what it can lead to, really, where the machine decision was being trusted over the human one, and it took years to unravel. How do California's ADMT requirements try to address that risk specifically? And can you tell me where do you see organizations getting it right or getting it wrong, and what are these early implementations?
Yeah, another great question. So obviously it was something we were concerned about. And I think that example I just provided really kind of hits at the core of what you're describing of being concerned that whether it's, not physically or temporally enough time to actually complete a decision or complete a meaningful review, or whether or not it's actually overly relying on a system's sort of outputs. This is something we were definitely thinking a lot about as we helped develop these regulations. But in many ways, I think it's what those three categories of requirements that I described earlier does address somewhat directly, right? So this is to say, um, we think we reduce the chance of bias when you have a human who knows how to interpret and use the technology's output to make a decision, right? Somebody who is actually trained and understands the potential pitfalls of the technology or where it could be making errors. Hopefully with that sort of full understanding and comprehensive understanding of the technology you're using,
Mhm.
you know when you should be making divergent decisions potentially from what it's suggesting. Similarly, being able to review and analyze the output of the technology and other information to make relevant that's relevant to make a change potentially. It's taking sort of your totality of the circumstances under consideration and not just allowing sort of a simple readout from ADMT sort of output to determine
Yes.
something, right? It's really understanding that if you have other information, you need to be considering that as well and let that sort of go into your actual human decision making. So these, in our opinion, these are common sense requirements that really align with how we expect a human to be involved in the decision making process, particularly when it comes to significant decisions such as whether a consumer is hired or fired from a job.
Yeah.
I realized I maybe skimmed over that at the beginning too. So just to clarify for everybody, it's not necessarily all uses of ADMT in a business's workplace that we're talking about. Our
Mhm.
agency did focus this to be uses of ADMT to make a significant decision regarding whether or not certain sort of essential goods or services are provided to that consumer, or provided or denied it. So things like healthcare, financial opportunities, job opportunities, things of that nature. So that's another scoping element of what we're discussing. So before people think, oh man, every single use of a decision-making technology is subject to these requirements, I want to make clear there's sort of this additional threshold down that usage path that really comes back to, okay, how is this being used with respect to a consumer? And in many ways, we focused on where could consumers be harmed the most.
Yeah, so it's immediately applying to what's effectively a higher risk tier, that's,
Yes,
yeah, yes,
exactly.
completely.
And then finally, because I didn't forget the rest of your question, sort of what are we seeing in terms of business compliance? So the truth is,
Yes,
our ADMT requirements don't actually kick in until January 1st of next year.
of
So
course.
I'll say this again, I'm sure this is a great time to be preparing for these requirements now. They are not in effect yet. They will be in effect in about 6.5 months. So we're certainly eager to see sort of how these play out and get used. Sort of in industry and in practice, but at the same time, we'll definitely be reviewing as these roll out to see if there's any deficiencies, or going back to your point, if we're still seeing instances of automation bias and we figure out ways we can better address that. That'll always be on the table. We'll always be looking to refine these requirements.
Yeah. So I suppose now is the runway to get it right for people so that they can hit the ground, they can hit the ground running whenever it is time, whenever enforcement is there. Yeah.
That's
Yeah.
exactly right. That's exactly right.
That brings us nicely then to the roadmap that most of the audience will need to plan for. And two major implementation milestones on the roadmap most of the audience need to be prepared for are the risk assessment requirements and the drop platform. So could you take us through the risk assessment timeline first? What businesses are in scope? What do they need to produce and when? I think we've sort of touched a little on those points as we've gone, but could we go through it in order?
Yeah, absolutely. Happy to. So let's go ahead and start with scope. If you're a business under the CCPA, which is sort of a defined term and has certain thresholds you have to meet in California,
Mhm.
you need to conduct a risk assessment for activities that present significant risk to consumer privacy. And again, I'll just mention this is another one of those nuggets from the law that was stated without being defined. And so that was sort of the challenge and task for the agency, was to really flesh out what we thought and what our board thought were significant risks to consumer privacy that require this type of review.
Okay.
Um, so the agency's regulations detail what these activities are, though. At a high level, the risk assessment requirements are triggered if your business wants to sell or share personal information,
Mhm.
process sensitive personal information, such as collecting a consumer's precise geolocation, use ADMT for significant decisions, such as employment decisions, or use or train certain automated technologies. So I always encourage people to actually go read the actual regulations and not rely on my
Yeah.
summary descriptions of these things. Of course, the lawyer in me can't help but give that disclaimer. But these are sort of the core triggers for when you have to do a risk assessment. Now, in terms of okay, now you know you have to do a risk assessment. What do I actually need to do? So the first thing is to conduct our risk assessment. And so our regulations do detail sort of what's required in terms of what sort of assessment you're supposed to do of the processing, what things you're supposed to consider, what you need to document in that process. So, for example, the business would need to identify and document in a risk assessment report certain operational elements of the activity, such as the approximate number of consumers whose PI the business plans to process, disclosures it plans to make to consumers about the activity, etc. So really, it's encouraging and requiring businesses to think first before they act when it comes to these sort of heightened sensitive uses of personal information. Now, on timing of these risk assessments, I want to make clear because on all the things we're talking about, these are sort of in different phases of going into effect. The risk assessment regulations did take effect January 1st of this year. So businesses that are starting new processing activities in any of those four buckets I just described should be are required to be conducting their risk assessments first before starting that activity. However, we understand there's plenty of processing that's covered in those topics that is already underway, has been underway for potentially years by businesses. And there's essentially a catch-up window allowed where businesses need to have those risk assessments for activities that were already in place, moving ahead as of January 1st of this year. They have to have those done by December 31st of next year, 2027.
Right.
So about 2 years to play catch up to get risk assessments documented for all the processing that meets that criteria. And then the second thing a business needs to do after it's prepared these risk assessments is it does need to come back and update its risk assessment at least once every 3 years. At least every 3 years, you should be dusting it off to make sure it's still accurate, make sure it still reflects everything that's occurring within that processing activity as it was initially planned. But in addition, there's actually an affirmative that's not a 3 year pass to just put it on the bookshelf and forget about it. There's an affirmative requirement that if you make any sort of material change to the processing, you do actually need to make that an update to your risk assessment reflecting that new change within 45 days of the change. So we want it to be dynamic. We also thought a 3 year check-in period was appropriate when your processing really doesn't change, but you still need to be considering, have my risks, benefits, anything changed in sort of the use of this personal information over the last 3 years.
Yeah. Okay. So yes, there's that fail safe in there that you will check, but as you say, it's dynamic enough to move that you have to change when you know there's change.
Yeah, exactly, exactly. We don't expect somebody to sort of add sort of a novel use or new type of disclosure to personal information without really considering the impact of the original processing.
Yeah.
And then the third requirement after you've gone through these exercises, you've kept on top of your risk assessments is there is an affirmative requirement to submit a high level description of your risk assessments generally to CalPrivacy, to our agency. So starting in 2028, annually, businesses will need to provide information to the agency about the risk assessments. And that includes things like the number of risk assessments you completed overall, and categories of PI and SPI involved. So again, these will not be the risk assessments themselves necessarily. It'll be just sort of a summary description of that work. But that is an annual submission requirement beginning in 2028.
Okay, excellent. And then if I can, I'd love to look at how the likes of the California risk assessment requirement interacts globally or, with other regulations. So from where I'm sitting, I've got to ask, does it interact with risk assessments businesses may already be doing if they're working with the EUI Act or GDPR or other sector specific regimes? Is there meaningful reuse there, or would you just see those as genuinely separate exercises from your seat?
Yeah, there is potentially very meaningful reuse. This was something our board was very focused on as we developed these regulations. And in fact, it's in our underlying statute that created our agency, sort of this obligation for our agency to work with other jurisdictions and other privacy authorities to make sure there's alignment as much as possible, because obviously it doesn't serve anybody if we all come out with conflicting standards that businesses can't comply with across jurisdictions. That's not good for the business, that's not good for consumers, that's not good for regulators. So the board did discuss at length how to ensure risk assessment regulations harmonized with other frameworks. This interoperability effort is reflected in the risk assessment requirements in section 7152 for anybody who wants to get out their CCPA regulations. Most of these requirements do overlap significantly with what a business would need to comply with other frameworks, such as GDPR. Or another one that was sort of top of mind for us because it was one of the few other risk assessment sort of regimes in the United States was state of Colorado's their own
Yeah.
risk assessment requirements. So um, the regulations explicitly allow for the use of other assessments to fulfill the obligations, but it's not sort of a safe harbor. Well, if you did it for them, it's good enough for us.
Mhm.
The requirement is essentially you can reuse the same risk assessment for our jurisdiction. Just if it's missing anything from our requirements, you'll need to supplement it with what's also in our requirements. So so again, we recognize this, it's only practical probably for somebody to do a single risk assessment for processing activity. We just want to make sure it covers, you would want to make sure it covers multiple jurisdictions requirements, including California's.
Yeah.
I will also just give you the tiny nugget that we have an example in our regulations of
Mhm.
another framework that if you did X, Y, and Z, here are the only things you would need to supplement to make it a California compliant one. We gave that as an example to really flesh out what we were talking about how you could supplement what I'm describing to you right now. But the
Yeah.
little secret I will tell everybody is it's based exactly off of Colorado's existing risk assessment requirements. So it is a little cheat sheet baked into our regulations itself on what to do, at least at that point in time. As you can imagine, part of what we have to be cognizant of is a state like Colorado, anybody in the EU could change their requirements at any time, and we wouldn't want to suggest ongoing that the alignment is the same without making proper updates.
No, of course, but there's obviously going to be a great degree of relief for some that they're not starting with a fresh page, and it's coming. If it's coming right from you guys, that's an absolutely acceptable place to start. That's a very different day's work.
Yes. Oh, absolutely. Yeah. No need for CalPrivacy specific branding at the top of your
Yeah.
risk assessment. Just make sure it has all the requirements and we're happy.
Excellent. I love that. So, something that I touched on then, a couple of questions back, just in passing, then was drop the delete request and opt out platform. So, it's one of the more architecturally ambitious elements of the regime, and it's providing a centralized mechanism for consumer delete requests, opt out signals across businesses. Can I ask, where are we in the build, and what should businesses be doing operationally to be ready for that?
Yeah, great question, and something I could bend your ear probably too long about. Coincidentally, as a small new agency in state government in California, this task got added to our portfolio in 2023. A law passed the Delete Act, which is essentially the other major law we implement and enforce, and it gave us this mandate to develop the drop system, which again, as all for anybody who isn't familiar with it. Our agency currently hosts a data broker registry. So if you meet our definition of a data broker in California, you have to register annually with our agency, make a number of disclosures, and that's a publicly available list. This year, I think we have it. We just posted the 2026 registry last month. And I believe we have well over 570 data brokers registered with our state right now. But what the drop system does is it takes that a step further. And what it now requires is those data brokers who are registered with our state and doing business in California as a data broker, they are now required to come to our system. I guess I'll start on the consumer side. Consumers can come and make a one-stop request. They can come to our agency's website, enter pretty minimal information about themselves, and then submit a deletion request that will ultimately land with all of those 570 plus data brokers that are currently part of our drop system. And that request they have to pull, they have to determine if they have a consumer profile that matches the information provided by that requester. And if they do, they have to delete that person's information, and they have to do all this within 45 days. And that's an ongoing cycle. So
Yeah.
where we are in the drop build and anyway, so where I started earlier is just simply the funny fact also is that for a period of time, I was actually the deputy director in charge of developing this, which again is kind of a joke. Sometimes I laugh that a lawyer is the last person that should have been doing this, but in many ways, I actually want to encourage your listeners that I actually think it was a great implementation of a tool. I mean, here we got to kind of stand in the role of industry, or at least tech industry, build a product for consumers. And I actually think having lawyers so intimately involved every step of the way, from the architecting phase to the execution and delivery phase, um, means we were able to address those legal questions very dynamically and feel confident that as we've rolled the system out, that it meets our legal obligations and is a good demonstration of how legal engineers and everybody can work together on a project and deliver, a compliant but still very successful product. So, with that little pitch, I'll go back to
Okay.
where we are and what we've done. So, January 1st is when we launched Drop for consumers. So, since January 1st, Californians have been able to come into Drop and submit their request. And to date, I'm happy to report we're now over 290,000 Californians have already submitted a request.
Okay.
But the funny thing is, data brokers aren't actually required to start deleting information based on those requests until August of this year. And I say that's funny because that's how much interest we've had without data brokers even doing the deletion function yet. These are just
Yes.
people who wanted to get on the wait list for this function, essentially. And we're already at over 290,000. But come August, that obligation kicks into gear for data brokers. So coming back to, okay, what should businesses be doing to prepare for this requirement?
Mhm.
With this one, I cannot emphasize enough is first, please read our definition of what it means to be a data broker, and then read the regulations that further define what it means to have a direct relationship with the consumer. Because our definition of a data broker is it's somebody who collects and sells to third parties personal information of consumers with whom they do not have a direct relationship. But you're going to detect a theme here, Matt. Once again, that was not defined in the law. We had to define what it meant to have a direct relationship.
I had a
And
feeling that's where you
so,
were going. Yeah.
yeah, you thought, okay, I think he's teeing me up here. And so, in defining that, we really made clear that that direct relationship is not just a one and done type of relationship with a consumer. It really is driven by where the information was collected and how that is happening ultimately across your business practice. So this is to say, a business can have a consumer-facing function, can have a product that they sell, a public website where consumers come to shop for things or purchase a service or anything like that.
Yeah.
But if they are also separately collecting information about consumers and then selling that information
Yeah.
outside of the information they have just collected directly from that consumer through their interactions with them, they will still be considered a data broker under a law. So I say that because I think there's a lot of consumer-facing businesses out there that think, well, I'm not a data broker. Those are those people nobody knows anything about. But it is
Mhm.
very possible that you can be a data broker and also a consumer-facing business. In fact, just last week, there was an announcement, joint investigation with the Attorney General's office, investigation supported by our office and multiple district attorneys' offices just settled a case with GM, General Motors.
Mhm.
Obviously, big name vehicle brand, obviously has a consumer facing um, in sort of practice and business,
Yeah.
but also has been registered for years now on our data broker registry because they have recognized they are also collecting and selling information about consumers outside of those one-on-one direct interactions. So first, figure out if you're a data broker. If you are, then you should come set up a drop account immediately. You should if you were supposed to register. So registration is retroactive. So you register every January if you were a data broker in the previous calendar year. So if you're a data broker in 2025, you should also complete registration. If you're a new data broker here in 2026, just create your drop account. You'll pay us an access fee to kind of get access to the system. And then I'm happy to say we already have a sandbox set up for data brokers that have accounts where there can be testing their API integration. They can be testing. We use a lot of hashing in the way we share data and have data brokers compare it within their systems. Um, so testing out sort of all the technical details of how this integration works so that people aren't on August 1st and thereafter. We don't want businesses to be in that situation of, oh no, something is failing on the technical side. I don't know what's happening, and now I'm worried I'm liable. That doesn't need to be the case. We have tools available to you now so you can be prepared. So that is my message, Matt, is that anybody who's a data broker, make your account, start testing in the sandbox, and register if you were supposed to.
Yeah. The information's there. The tools are there. That they have the time.
Yeah, exactly.
So
Exactly. Yeah. Yeah. Again, August 1st. So we have at least 3 months here.
yeah. Okay. Excellent. Well, look, I mean, in a short time there, I think we've covered a lot of roadmap items, and we've probably gone back and forward a little between dates for beginning of this year, August of this year, end of this year, and end of next, the way those are all flashing out. I mean, if as a business I was looking at the 2026-27 roadmap and wondering, right, where do I need to focus my effort? Is there a single preparation gap that you're seeing? Is your experience that people are missing the same area, or is it spread, or what does that look like?
Yeah, I mean, for better or for worse, as the regulator, we don't often hear from industry about, where there are gaps in their
Hmm.
preparation. So we don't have a tremendous amount of insight into that. But at the same time, as I mentioned, there's a number of sort of rolling implementation dates for these requirements.
Yeah.
So certainly from our perspective, from my perspective, when it comes to the newer requirements, first and foremost, as I mentioned, risk assessments. That requirement already kicked in January 1st. So any new processing activities, you should be doing risk assessments now. So that feels to me like the most urgent. And as I mentioned, and you should also be paying catch up with your other data processing activities that need risk assessments because those will come due by the end of next year. So those are good things to focus on. At the same time, as I also mentioned, ADMT requirements start January 1st of next year. So again, thinking about this is a great time to be preparing for those requirements as well. By doing it now, then come January 1st, hopefully you have sort of your whole system implemented and it's just a matter of turning the on switch to that functionality. Um, Same goes even as what we are just discussing. Yeah, in fact, I'll put data brokers to the side and just say, rewind 4 minutes and listen to what I just said. Just do it now and get started right away. One other
Yeah.
component, though, I should mention that we haven't really discussed, but is part of that bigger package of new requirements we adopted last year. There's also an annual cybersecurity audit requirement
Mhm.
for businesses going forward that have processing activities that are potentially risky to security of personal information. And so, with that in mind, it's a phased rollout where certain businesses, basically businesses with a revenue of over $100 million a year, have to do their first audit in 20 or have it completed by 2028. Businesses making over $50 million a year by 2029, and all other businesses subject to that requirement by 2030. And I bring that up now because you may be a business that thinks, well, that's not until 2030. That's a lifetime from now. But we recognize, especially for those that are on the earlier side of that spectrum, reviewing your personal information, mapping your data systems now, and understanding where personal information lives within your sort of business's ecosystem will be invaluable to helping you not have a hard time when those requirements actually kick into place. So these timelines I want to just mention were very thoughtfully put out with all of this in mind. We knew businesses couldn't just flip the on switch on all of these requirements in 3 months. So this phase in is sort of intentional so that businesses can kind of focus on one thing at a time. So right now I'd say risk assessments, ADMT, and drop, but at the same time, don't forget about this cybersecurity audit just around the corner.
Okay. That's something I kind of feel doesn't get said enough. I think it's very easy to think of deadlines and think of, as you say, these roadmaps in terms of how far away they are, not in terms of we've set that roadmap so you have time to get it done, and yeah, I think it's a very human thing, but a very easy thing to fall into that trap. And right, well, that moves us on to the third offer, the third area that I said at the top we would cover. So the CPPA or CalPrivacy has been increasingly explicit that compliance has to be evaluated against real world user experience, and the exercising of privacy rights. So it's not just the existence of that right on paper. Could you talk through why frictionless became the framing that the agency's chosen? And I suppose, if I can push you for an example, I mean, what kind of friction does the agency consider unacceptable?
Yeah, great question. Great question. And to kind of set the stage a little bit, if you look in our law, you're actually not going to see the word frictionless. You will see that actually referred to in our regulations, and but that I want to clarify is really sort of specific to describing a particular way that a business can honor a consumer's request to opt out of business selling of their PI or sharing for cross-contextual behavioral advertising. But I don't think, Matt, that's the frictionless you're talking about. I think you're alluding more generally to this idea of easing the path for consumers to use these rights
Yeah,
across the board. And so In terms of what we're focused on, I mean, the agency at its core is focused on practices that create sort of what we consider unnecessary barriers for Californians, and how we can remove obstacles that prevent Californians from exercising those privacy rights. So you were asking for examples. I think the work of our enforcement division provides some really important examples. And if you haven't read the settlements they've landed and our board has adopted already, they're really sort of their own windows into perspectives of the agency and our approach to these issues. So, agency has taken action against several companies for failures related to opt-out rights, including failures that resulted in unnecessarily friction to consumers on how they exercise those rights. So really, what we're trying to drive home is, for instance, under our law, businesses cannot require consumers to verify their identity to opt out of sale and sharing, and cannot require more information than is necessary to process requests. Instead, they have to provide consumers with effective means to opt out. They must provide privacy choices in a way that is equal and symmetrical, and they must recognize and honor these opt-out preference signals. So we've had settlements with a business called Tractor Supply Company, Honda, who you might have heard of, Todd
Mhm.
Snyder, Ford, Play on Sports. These are all settlements that, again, if you have some time and go dig around our website, I think there's a lot of interesting takeaways of where we're focused. But I think at its core, there's this idea of, I mean, if we think back to the framework of privacy and how it's been adopted in California and maybe internationally in many ways, well, at least in California, I'll speak to is um, we've landed on this. It's opting out, right? It's not opting into certain uses of data use and personal information processing. So, with that in mind, you've already put the consumer in the position of having to take an affirmative step with the business to sort of further protect their personal information. And with that being the case, I think the general focus of the agency and what you'll hear kind of discussed in different ways across board meetings and through enforcement actions is this idea that we recognize we have to be careful about how these rights are implemented. Obviously, we recognize that the potential harm and fallout of an improperly used right to delete or right to correct can have a different effect than right to opt out of sale or sharing or right to limit. So we recognize there's sort of a spectrum of the types of verification needed, for instance, for some of these rights. But our law really lays out what those requirements are. And what we don't want to see is somebody sort of skirting those requirements or blending them in ways that the law doesn't support. Because the law did try to set a framework that makes it easy where it can be easy for consumers, understanding they're already having to take time out of their day, taking an extra step to sort of exercise these rights. So I think that's really at the core of what we're doing. In addition to sort of the work and the stories, I think that come out of the enforcement division, I want to just also mention our agencies generally consider pretty broad rulemaking topics right now. We completed our mandated regulations through from the proposition, but I've been in sort of state regulatory work for years now, and the truth is, technology changes, business practice changes, regulations ultimately need to be nimble and addressing new concerns as they arise. So in many regards, a good regulatory agency is always looking at what's ahead and how we can better prepare businesses and better protect consumers. So right now we have a number of rulemaking topics that our board directed us to do investigations on where we think we could better tighten up sort of the requirements or better clarify them. And one of
Mhm.
those is on reducing friction. So I just say that because it's something we're highly engaged in. We just closed a public comment period for that topic. Their comments received are actually already available on our website if anybody's curious what the public is telling us about this issue.
Yeah.
But I think the theme you'll see through complaints, essentially is um, consumers want to be able to exercise their rights. They don't want to run into so much red tape that they can't actually finish the task they set out to do. And at
Yeah.
the same time, we recognize businesses want to comply with the law. And if there's something not clear in the regulations, we want to make it more clear so they have an easier time setting up that system for consumers.
Yeah. I mean, it's an honest tension, isn't it? Between that, you're making the privacy right frictionless for the consumer, as you say, but there's a reason that you need to be able to authenticate requesters, and the operational
Hmm.
reality of that is something that, as you said, business has to deal with, whether it's preventing fraudulent deletion, as you say, or even just applying the right exemptions. I mean, you're clearly thinking a lot about that balance. What is an organization that's getting it right look like? If I think we've talked a lot there about the consumer side of that from the organization side of it. What does good look like?
So, Matt, that's a great question. Taking a step back, this is something that's sort of been since the beginning an issue that the Attorney General's office, when they had rulemaking authority, and our office has been contending with, and a balance that we've been seeking to strike. And as I've already mentioned, at least that question of which rights need verification and which rights don't, that's really been addressed in the law. That is not something that we were necessarily given authority to sort of define ourselves, unlike so many other things in our rulemaking. That's something that's pretty clearly stated. And so what you'll see in our regulations, I think, is an effort to uh, hone those requirements and better explain what it means is sort of unnecessary verification, or what it means to even reasonably identify an individual. So, I'm going to give a few examples. The regulations require business to use a reasonable method for verifying certain types of requests. So, this is requests to know, to correct, and to delete, and also to access meaningful information about how ADMT is used with respect to a consumer. But they really provide guidance and flexibility to businesses for them to determine their verification method. So, um, regulations require business to match identifying information the consumer provides to the information the business has before asking for more. So, for instance, thinking about what do I already have about this consumer? What do they have? Can I make a reasonable verification with that? And so, requiring business to avoid collecting certain information unless it's necessary to verify the consumer. So things that businesses really should be considering is the type, sensitivity, and value of the personal information the business collects or maintains, the risk of harm to the consumer from unauthorized deletion, correction, or access, the likelihood that bad actors would seek the personal information, whether the information the consumer provided is sufficient to protect against fraudulent requests being spoofed, fabricated, um, how the business typically interacts with that consumer, and the available technology for that verification. So, for instance, if a business maintains a password protected account with the consumer, it can leverage its existing authentication practices for the account. Where consumer doesn't have or can't access a password protected account, the regulations articulate standards and provide guidance for businesses on how to determine which standard applies and how to meet the standard. Um, so again, we sort of, without going too much further into our regulations, again, I trust everybody can read. We sort of parse out what is a reasonable degree of certainty versus a
Yeah,
reasonably high degree of certainty, and I think really reading that carefully and recognizing where you can sort of comfortably make a verification decision with the information available. It's almost its own practice in data minimization, right? It's thinking to yourself, what do I really need to accomplish this? And not just thinking, well, we always know it's the person if they have an ID, so let's just ask for an ID, right? It's being a little bit more thoughtful and careful about matching the information you have with the information a consumer can reasonably provide.
yeah. That sums it up so well, doesn't it? Starting from that minimum point, you can't really go too far wrong. Yeah, excellent,
That's our
excellent.
goal.
Yeah.
Yep.
Brilliant. And look, if I can ask you one more, over the next 12 to 18 months, and across the areas we've discussed, where do you most want to see organizations make progress? And conversely, where do you think the widest gap is going to be between the current practice and what the regulation actually expects?
Yeah, great question. As I think about that, I think the most important thing to us is compliance. So we want to see businesses complying with the law and with these new regulatory requirements as they come into effect. I think that's why I've talked so much about using these sort of ramp up opportunities to get
Yeah,
prepared now. And obviously, I know it's hard to get motivated before the statutory deadline is here, but we never like to see anybody who's failing to comply day one because they put it off, right? That's not a great target for anybody. So from our perspective, simple compliance with the regulations is fantastic progress, to ensure that they are protecting consumers' privacy as required. Is really what we want to see. We know, though, that businesses are busy implementing new risk assessment requirements and preparing to implement these additional requirements I referred to regarding ADMT and cybersecurity and potentially drop if you're a data broker. And we recognize that these can be very resource intensive and take a lot of attention. But just to remind folks, it's our mission at CalPrivacy, at least, to protect consumers' privacy. And as the public is seeing from the Enforcement Division's action, the agency is taking action against businesses where it finds evidence of violation of the law, especially those situations where there's been ongoing violations with requirements that have been in place for a while. So I'll remind folks, there is at least a sort of broadly stated discretion to our enforcement division to at least consider the length of time a law or regulation has been in effect and the good faith efforts of a business to comply. So, good faith effort to comply goes a long way at our agency. I don't oversee enforcement, so I can't speak to actually how much credit that'll get you with them, but I'm pretty sure from what I've seen, good faith efforts to comply makes a lot of difference. But at the same time, we still have consumers to protect. These requirements were established for a reason, and we really do anticipate businesses have the opportunity and can come into compliance fully in this timelines we've been discussing over the next few years, if they prioritize it now.
Excellent. Phil, look, thank you. That was I think, a really useful walk through the three areas that we know our audience need clarity on. And I think governance leads are going to come back to this as the 2026 milestones approach. For listeners who want to go deeper on the CPPA, on CalPrivacy's work, the agency publishes its regulations, guidance, and updates at privacy.ca.gov and at cppa.ca.gov. And you can find previous conversations, including the one I mentioned earlier with Sophie and Teveld, at anz.ai/learn/podcast. Phil, thanks so much for joining us, and thanks to everyone for listening to this episode of the AI Governance Podcast.
Thank you, Matt.